May it please the court, I'm Thomas West from the Overland Park, Kansas Bar. I am the appellant in this case. According to the U.S. Supreme Court,
Want to save any time?
I apologize, Your Honor. I would like to reserve 5 minutes for rebuttal.
5 minutes, okay.
Apologize for that little oversight. According to the U.S. Supreme Court, a state statute can discriminate against interstate commerce in one of three ways: facially, purposely, or in practical effect. Professional privilege tax discriminates against interstate commerce in practical effect. In the case of American Trucking Associations versus Michigan Public Service Commission, the U.S. Supreme Court noted that the Michigan fee there taxed purely local activity, and it did not tax an interstate truck's entry into the state. That case was a unanimous ruling by the court, and in the concurrence by the late Justice Scalia in that case. He explained to the petitioners in that case that the Michigan fee is distinguishable from their best analog, the fees invalidated in American Trucking Associations versus Shiner, which applied to interstate trucks even when they engaged in no interstate business. The trial court held that the professional privilege tax does not discriminate against interstate commerce, passes the U.S. Supreme Court's test of internal consistency, and is fairly apportioned.
Can I ask you a foundational question before we delve more deeply there? So you've indicated that you're raising a facial and an as-applied constitutional challenge in this case. Can you, in looking at the state's brief in opposition, I want to make sure I understand the scope of what you're talking about with regard to your facial and as-applied challenge here. In what respect are you raising a facial challenge? And so what's the scope of that you envision in terms of your facial constitutional challenge in this case?
Well, the facial challenge, I submit that there are no circumstances under which the statute as it exists can be held to be constitutional in light of the dormant interstate commerce clause.
Isn't it constitutional as applied to in-staters? I mean, at the very minimum, I mean, there's no violation of dormant commerce with regard to application of the privilege tax to Tennessee residents, right?
That would be correct, Your Honor.
What about an out-of-state attorney? I mean, we have more than a few out-of-state attorneys that live in northern Mississippi who practice in Memphis. And is it constitutional to apply it to them, where all of their legal practices in the state of Tennessee, they just happen to reside across the border and thus are Mississippians rather than Tennesseans, but they practice in the state of Tennessee?
That is true. They live in Mississippi. But the key detail really is that the U.S. Supreme Court is concerned in these cases with the cost per business unit.
I understand. I'm just trying to get down the scope issue in terms of the challenge.
Understood. And I probably was a little confusing because there are, as the court knows, there are facial challenges, like you challenge something on the face of it, or you challenge it because it discriminates on its face, such as in this case, if the professional privilege tax said an out-of-state attorney must pay $800 and an in-state attorney pays $400. That is not the situation here.
Well, aren't we talking about two different things there, though? You're talking about a facially discriminatory measure, like a Philadelphia v. New Jersey style dormant commerce facially discriminatory measure versus the nature of your challenge being a facial constitutional challenge. If it's a facial constitutional challenge, and get to it as applied in a minute, doesn't it have to be unconstitutional in all applications to be facially unconstitutional, the statute to be facially unconstitutional?
I believe it had to be, there should be no set of circumstances, at least, under which an out-of-state attorney, it would be constitutional insofar as an out-of-state attorney.
Would you agree with me that it's constitutional as applied to my Mississippi attorney who, lives in Mississippi but practices in Memphis attorney, that there's nothing unconstitutional about applying the professional privilege tax to that attorney who does 100% of their legal practice in the state of Tennessee? They just live across the border in the state of Mississippi?
In his specific case, I could see such an argument. To be honest, I do not know.
Well, okay, so let's talk about the as applied here.
Okay.
What's the scope of the state characterizes your as applied challenge as to attorneys, that it's unconstitutional. Professional privilege tax is unconstitutional. and your as-applied challenges as to attorneys. Is that an accurate rendering of your as-applied challenge as you understand it, or is that an inaccurate rendering of your as-applied challenge?
I would say probably inaccurate. Obviously, the state would be very quick to argue, and has argued, that I only have standing to bring an argument insofar as attorneys. I am not a stockbroker. I am not a sports agent or some such as that. So I probably is fair to say I don't have standing to bring insofar as that. But whether I were such a person, I think I would have the same standing in such a role than I do as an attorney. Regardless of the role, it's still subject to the tax.
Let me ask you an as-applied question then in terms of scope with that. You, in your brief, state a number of hypotheticals, right? You say, well, there's a difference between an attorney that's out of Kansas, for example, who may have 2 cases a year in Tennessee versus a Tennessee attorney who has 200 cases a year. Those may not be the exact numbers from your brief, but I think it's the concept from your brief. Do we have any facts here in your brief that give us the facts of your circumstances to consider an as-applied challenge? And I read your brief as stating this as a hypothetical, that you have 2 cases in Tennessee versus 200. Do we have the facts from which we could decide an as-applied constitutional challenge? And there's some tough line drawing in dormant commerce analysis. Do we have the facts before us to resolve that kind of determination in this case?
Well, if the court would refer to the record in Volume 2, in which there were affidavits by a number of attorneys, myself included, but notably one attorney, Catherine Corliss of Arkansas, who has no Tennessee business. Therefore, she's hit full force against her Arkansas income with an actual real-world situation. But for reasons that she stated in her affidavit, she must keep her Tennessee law license active in case her employer were to be sued in a Tennessee state or federal court. So that is such a case. Another one, in another set of attorneys, there are, I think, about 291 attorneys listed by the Tennessee Bar Association who have been suspended expressly for failing to pay the professional privilege tax. So I would submit that at least the professional privilege tax definitely causes problems for these out-of-state attorneys. These are real-world situations in that. And of course, my own case, I have no actual Tennessee clients at the moment. I could at some time, but I don't at the moment. So I don't. The professional privilege tax hits me, my Kansas income, full force, because I have no Tennessee business to cover it as such. But the trial court stated that the professional privilege tax does operate as an entry fee, unlike the case with the fee in the Michigan Public Service Commission case. Professional privilege tax thus applies to interstate attorneys even if they engage in no Tennessee business, just like in the Shiner case. In the Shiner case, the Supreme Court did hold that so long as a state bases its tax on a relevant measure of actual road usage, obviously both interstate and intrastate carriers pay according to the facilities in fact provided by the state. But a tax for the privilege and not their actual use may in the normal course of operations involve an undue burden on interstate carriers. And that's why how, according to the Supreme Court, Justice Frankfurter illuminated the reason that a state's imposition of an unapportioned flat tax discriminates against interstate commerce. The professional privilege tax is a fee for entering the state of Tennessee for the purpose of engaging in commercial activity, specifically the practice of law. But the U.S. Supreme Court held that if each state imposed flat taxes for that for the privilege of making commercial interests into its territory, there is no conceivable doubt that commerce among the states would be deterred. The First Circuit Court of Appeals held in American Trucking Associations versus Rhode Island Turnpike that the toll regime there, as in Shiner, meaning the tractor trailers there staying within state borders would pay on average substantially less substantially less per mile than would out-of-state trucks. Finally, the state argues that it doesn't require the states to avoid flat taxes where they're the only practical means of collecting revenues. But 3 states already collect a sales tax from attorneys for the services they provide: New Mexico, South Dakota, and Hawaii. I thank the court for its time.
Thank you. You'll have your rebuttal time.
Thank you.
Good afternoon. May it please the court. My name is Laura Hall, and I'm here on behalf of the state. As opposing counsel mentioned, we're here to discuss the Tennessee Privilege Tax and whether it's constitutional. The statute imposes $400 annually on all attorneys seeking to practice in Tennessee, regardless of where they reside. Opposing counsel is seeking to overturn the unanimous lower court decision, which held the Tennessee Privilege Tax did not violate the Dormant Commerce Clause. As I'm sure you're aware, a state tax challenge under the Dormant Commerce Clause is evaluated under the test in complete auto transit, and such a tax is constitutional when it's applied to an activity with a substantial nexus to the taxing state, it's fairly apportioned, it does not discriminate against interstate commerce, and is fairly related to the services provided by the state. Now, there are 3 ways in which a statute can impermissibly discriminate against out-of-state interests: facially, purposefully, and in practical effect. On appeal, plaintiff is arguing the Tennessee Privilege Tax discriminates in practical effect. Plaintiff claims that the 3-judge panel failed to consider the decision in Shiner, which reads, "A state's imposition of an unapportioned flat tax discriminates against interstate commerce." However, the facts in Shiner differ substantially than the facts in our case, and plaintiff misinterprets the holding. Shiner involved a Pennsylvania statute that required all trucks to obtain and display an identification marker. Prior to 1980, the marker fee was universal to everyone. After 1980, they raised the marker fee, but exempted trucks in Pennsylvania and raised the registration fee. Then in 1982, they implemented an axle tax. But again, they gave Pennsylvania vehicles a reduction in registration fees to offset the price of that axle tax. So first and foremost, the Shiner case is distinguishable because the marker fee treated in-state truckers and out-of-state truckers differently. Further, Pennsylvania treated in-state residents better by offsetting that axle tax and the registration fees. It was that blatant discrimination that invalidated the tax in Shiner, not just because it was a flat fee.
I'm trying to figure out the activity here. Opposing counsel references this in terms of cases, with the idea of cases as the activity. Is cases the right way of thinking about activity in terms of a professional privilege tax? Is that how we should understand it?
No, Your Honor. We disagree. Obviously, the practice of law is very expansive. Attorneys can do all sorts of things that don't reflect the litigation of specific cases. They can be mediators, representatives, lobbyists, all kinds of different positions. Consultants, and we don't think measuring it on a case-by-case basis is a proper method because of that.
Is the activity the ability to engage? I mean, professional privilege tax, is it the activity the ability to engage in the practice of law in the state of Tennessee?
Correct. It's the privilege to engage in the practice of law, not necessarily the practice of law. And there is a similar case regarding the practice of medicine. I believe it was Simmons. Let me get that for you. Versus Johnson, where this discussion was held, the difference between engaging in the actual practice of law versus having the privilege to engage, or in the practice of medicine, versus the privilege to engage in the practice of medicine.
And if we think about it in terms of the privilege to practice law, is there any variance between in-staters and out-staters, even in terms of practical effect, with regard to the professional privilege tax? So if what you get in terms of activity is the privilege to practice law, do in-staters and out-of-staters get the same privilege to have the opportunity to practice law?
Correct. They get the same options, right? They get to decide, are they going to litigate cases? How many cases are they going to litigate? Whether, that imbalance that plaintiff's referring to in his briefing is felt by both in-state and out-of-state attorneys, depending on what they do, depending on how many cases they have. It shouldn't be measured by the number of cases, because that's not adequate to what the licensure is providing and what the tax is covering, right? It's a privilege of the option to engage in the practice of law.
Is this the only method that a person can avail themselves of to obtain the privilege of practicing law in Tennessee? In other words, can you be admitted pro hoc?
Correct, Your Honor. There are other options. You can be admitted pro hoc vice. There are
Do you have to pay the privilege tax if you're admitted pro hoc vice?
I don't believe so, Your Honor. And then there are avenues to renew your license if you have become inactive. Depending on how long, there are different time periods and restrictions depending on why you became inactive. So there are other avenues that these individuals can take if they decide that paying the privilege tax is not financially worth their business in the state. But again, that's still a decision that is felt even-handedly for attorneys in state and out of state, which is why the statute does not discriminate. Second, the three-judge panel determined the privilege tax was properly apportioned. The lower court applied the test laid out in U.S. Supreme Court case Jefferson Lines, which states, a tax is not fairly apportioned if it operates in a way where the amount of tax collected reaches beyond that portion of value that is fairly attributed to the economic activity within the taxing state. The lower court correctly determined that the tax is seeking to only tax the privilege of practicing law, and it's not seeking to tax the privilege of practicing law in a different state. And because it's not seeking to tax an activity outside of Tennessee, it is properly apportioned. Third, plaintiff's analysis of Shiner fails to account for the more recent decision in the American Trucking case. That U.S. Supreme Court case involved a flat $100 fee that Michigan imposed on all intrastate transactions. The court upheld the $100 fee, finding it to be an unobjectionable exercise of the state's police power. They explained that states imposed numerous flat fees on local businesses and service providers and confirmed it would not recognize a dormant Commerce Clause restriction that unduly curtailed the state's powers to lay taxes to support state government. The court also determined that although the fee was imposed on business that was conducted both interstate and intrastate, it was only assessed on the intrastate portion.
Counsel, why isn't this an excessive burden on interstate commerce in terms of, so you, especially in a new regime in which we have multi-state bar exam, you can get broad admission across states, and states having professional privilege taxes like this, and this is not an insubstantial amount of money we're talking about here. And these can become a barrier to, I'm not going to take cases in the state of Georgia or Missouri or Mississippi because I'm not going to pay $400 for the one case that I'm going to be taking there. And isn't that a burden upon lawyers plying their trade across state lines in an era in which the multi-uniform bar exam, you can get admitted pretty easily in a lot of states?
Well, Your Honor, I believe that was also addressed in the American Trucking case, right? The claimant in that case argued if all states imposed that $100 fee, the interstate truck would have to pay significant fees to carry loads in local cities in all those states. But the court acknowledged it. The Supreme Court recognizes, yeah, you're going to have to pay more, but you're only doing so because you're engaging in local business in those states. The Dormant Commerce Clause does not seek to relieve those engaged in interstate commerce from their just share of the tax burden just because it increases the cost of doing business.
Is the professional privilege tax earmarked solely to support the judicial system?
No, Your Honor, it's a general revenue tax to support the state in general. But if you think about the amount of state resources it requires to maintain the courts, right, the filing systems, all of the workers in the courts, you're talking about a massive state expenditure, right? And so do I think the fee fairly represents the activities within the annexing state? Yes, because it is expensive to upkeep all of this, right? And I don't think it discriminates at the end of the day. And how much business plaintiff wants to have in Tennessee is up to him. Like I said, he can choose to remain licensed and practice Tennessee or choose to go inactive and not pay the privilege tax, just like the attorneys in the state practicing. But like we said, I think plaintiff's hypothetical also highlights why a flat tax in the practice of law is administratively reasonable. Because not all attorneys are being paid in the same manner or method, plaintiff's amount per case theory is again an impractical means of measuring legal work. And plaintiff completely ignores Shiner's holding that flat taxes may be perfectly valid when administrative difficulties make collection of more finely calibrated user chargers impractical, right? So having a flat...
Does the record contain any information about why that would be impractical?
I believe the state has discussed in the record, I know in the lower court, and we've had discussions at hearings in the lower courts below about the massive need for additional resources, both on the part of the state and on the part of the individual attorneys if we change the method and implement something like a receipts-based method, if it's even possible, right? You have attorneys who are contingency-based, salaried, flat fee, pro bono. The standard is it administratively difficult? Yes, this is why the flat fee makes the most sense, and that's why it's been implemented.
General, let me ask you a scope question here. Is your understanding of the scope of the challenge in this case that in terms of the facial as applied division, that facial is the professional, the challenge, the claim here, that it's the whole professional privilege tax, and the as applied is attorneys, so as applied to attorneys, or is this facially attorneys and as applied particular as to Mr. West?
I agree. It was unclear from the briefing and from plaintiff what exactly he was arguing, but it appears from his statements before that the facial challenge is to the privilege tax as it applies to attorneys, and the as applied, I would assume, is to the individuals, although it's unclear if the record supports the evidence of the as applied challenges.
Are there sufficient facts in the record for consideration of an as applied challenge as to Mr. West? And I noted, Mr. West brought up Ms. Corliss, and she's obviously not a listed party in the case. And are there sufficient facts here for the court to consider an as applied challenge as to involving Mr. West?
I would say no, because like you said, Corliss is not a party in this case, and Mr. West has brought this action, and he has not provided the facts to support an as applied challenge, and as he admitted today, he doesn't have any Tennessee cases. Absent, well, and I want to remind the court that the review on appeal is de novo, but statutes are presumptively constitutional. And for a facial challenge, the challenger must establish that no circumstances exist under which a statute as valid would be written, as you mentioned earlier, Your Honor. And that is a very high burden. Plaintiff has not met that burden. Absent congressional legislation, Tennessee has the power to make laws governing matters of local concern, which nevertheless, in some measure, affect interstate commerce. Like the Michigan tax, the Tennessee privilege tax is a permissible use of Tennessee state powers. And just because the tax is an inconvenience does not mean it's unconstitutional. For those reasons, we request the lower court decision be upheld. If there's no further questions, I'll rest, Your Honors.
Thank you. Mr. West.
Your Honors, to address a point the state made, the general made in her argument that a tax other than the professional privilege tax would be administratively impractical, I would point out that in the record, the Tennessee Volume 2 of the record, the Tennessee Advisory Commission on Intergovernmental Relations, they noted that the legislature initially considered a tax on services. But from all indications in that record, they apparently discontinued that consideration for political reasons. As I noted earlier, the states of New Mexico, South Dakota, and Hawaii actually have such a tax in operation on a practical level. So they are proof positive that such a tax can be done, it can easily be done, and there are no administrative difficulties so to do. That I'm certain the vast Department of Revenue certainly can handle any kind of simple administrative matters that may be needed to put such a similar tax into force. I would point out that the Supreme Court held in Commonwealth Edison versus Montana that the relevant inquiry under the fourth prong of the complete auto transit test is simply whether the measure of the tax is fixed as a percentage of the value of the coal taken, rather than a flat tax. The Supreme Court said that no trial would ever be necessary on the issue of fair relationship so long as the state is careful to impose a proportional rather than a flat tax rate. The state asserts that the Shiner Court stated only that a state's imposition of an unapportioned flat tax discriminates against interstate commerce. But the bottom line is what they were focused on was a percentage. And in those three states that use a services tax, they focus only on the intrastate business an out-of-state attorney generates. As a result, only the intrastate business gets taxed. No interstate or out-of-state business gets taxed.
Counsel, you, in your hypo and in drawing the distinction or showing the prejudicial impact,
Yes.
You draw upon the case concept. I wonder how that applies. And is the activity here really a case, or is it the privilege of being able to engage in the practice of law in the state of Tennessee?
Well, what is actually taxed currently, obviously, is the privilege of practicing law in Tennessee. The general noted that there are a number of people who do not engage in litigation. They are mediators. They teach law. They may be lobbyists or they're legislators. The point is, none of those professions or jobs involves the practice of law as such. They are not giving legal advice to a client.
They're still subject to the professional privilege tax, right? I mean, even if you're not giving, if you are a licensed attorney in the state of Tennessee or outside the state of Tennessee and want to be able to engage in the practice of law, whether you have a case or a client or not, you still have to pay the professional privilege tax, right?
That is precisely correct, Your Honor.
So how do you divvy that up? I mean, you're suggesting it's not proportional, and like the coal usage, road usage, the other comparisons. How does that work when you're talking about the ability to practice? I mean, doesn't everybody have the same ability, essentially, to engage in the practice of law in the state of Tennessee, who's a licensed attorney who's paid the professional privilege
Right.
tax? And so isn't it exactly proportionally divided up? Everyone gets the same thing. I have the privilege of practicing law in the state of Tennessee. Law professor example. They may not. I mean, isn't it really a mathematically perfect distribution?
Well, the point is, though, it's not quite so, because yes, it is for a privilege. But, for example, like Ms. Corliss or myself or others, if they don't actually practice law, but they must keep their law license active, then it creates a burden on interstate commerce that the U.S. Supreme Court has simply found unacceptable, at least in the Shiner case, and as they noted, at least in Justice Scalia's case, meaning concurrence in the Michigan Public Service case. That case, although the state asserts the Michigan Public Service case in support of its position, the reality is, the distinction is, that tax was not an entry fee like the professional privilege tax is, and on top of that, it didn't tax. I mean, that was the main key thing there, and it did not tax businesses or truckers went through there regardless of whether they did business in the state or not, whereas a professional privilege tax does. I thank the court for its time and consideration of this matter.
Thank you both. I believe That is the end of the docket for today. So if you would please adjourn court.